The insolvency administration of the companies Lyoness, Lyconet and myWorld has significantly improved the overall scope of the class action lawsuit against Hubert Freidl and former executives due to the insolvency and the insights gained from it. Based on the data available to us and the liability structures identified, it is possible that in addition to the usual court proceedings, direct claims against responsible persons can also be successfully asserted. This significantly increases the chances of successful implementation. We have invested considerable time and effort to find a litigation funder who will enable the aggrieved marketing employees of Lyoness, Lyconet and myWorld who are facing financial difficulties to pursue their claims and participate in a litigation process. To have the litigation funding agreement represented in the class action, we want to ensure that all marketing employees of Lyconet and myWorld have the opportunity to be represented in the class action lawsuit pursuant to the successful recovery of investments. Lyconet distributors must be aware that this service offers the last opportunity to assert claims in order to avoid the statute of limitations expiring. Regarding representation in class action lawsuits, the following crucial factors must be considered. Number one, the statute of limitations. Many affected individuals are unaware that their claims may soon expire. By joining the existing class action lawsuit, the statute of limitations can be effectively interrupted or suspended, therefore securing their claims. Number two, significantly improved prospects of success. Thanks to our direct access to insolvency data and the identification of specific liable parties, particularly at the management level, the proceedings now have a significantly stronger evidentiary basis. This enables a targeted and strategic approach and considerably increases the chances of success compared to previous phases. Number three, adjustment of the cost model, lower entry costs through success-based remuneration. Thanks to the services of the litigation funder, we can now offer a significantly more accessible model. Reduced upfront fees of 4.5% to lower the barrier to entry, in exchange for a total remuneration of 40% in the event of success, including the litigation funder and our fees. Under current civil law, successful plaintiffs are also entitled to 4% interest for a maximum of 3 years retroactively. Number four, data access blocked. If you no longer have access to your data, we can have it retrieved for you. This is a separate service costing €310. This amount will be credited towards any further services you may require. Some key contextual points to consider. In the market, litigation funders typically already cover 30 to 50% of the net proceeds. Against this backdrop, our total cost structure of 40% represents a comparatively very favourable solution, especially considering the reduced initial risk for participants. This model creates clear incentives. Getting started is easy, and compensation is consistently linked to actual success. From a strategic point of view, this positioning should not be seen as a speculative opportunity, but rather as a structured, data-driven enforcement measure with clearly defined legal procedures and realistic access options. Lyconet distributors who have not filed claims and wish to take advantage of the possibility of litigation funding should contact BE Conflict Management to have their claims drawn up and prepared for submission so that they can be represented in the class action against Hubert Freidl and those responsible. We will gladly send you a short form. You can have your claims reviewed. If you no longer have access to your data, we can restore access to it for you separately.